Something fundamental shifted in New York City this week. Many Jews felt it immediately. Zoran Mamdani was sworn in as mayor, and within hours, the guardrails came down. An international definition of anti-Semitism used by democracies around the world, erased. The prohibition blocking BDS by city agencies, gone. A lawyer who represented an al-Qaeda terrorist and a ringleader of illegal anti-Israel protests at Columbia University is now the city council. Even the previous mayor's public statements condemning anti-Semitism were quietly erased. None of this should be a surprise, and none of it should be viewed in isolation. Because when you strip away the language of process and policy review, what's left is a very clear message about the direction of the city and about whose safety is negotiable. Now, to be fair, the mayor kept the Office to Combat Anti-Semitism. He kept promises to protect houses of worship. But an office without a definition is like a fire department without water. It looks reassuring until the fire starts, and many believe that the fire is already here. From mobs chanting for violence outside synagogues, to a city official suggesting that Jewish immigration to Israel violates international law, to a political ecosystem where anti-Zionism and anti-Semitism are increasingly indistinguishable. This is not theoretical. So today, we talk about power, about law, about leverage, and about what actually protects a community when the politics turn hostile. Panic is useless, and fear is not a strategy. But used properly, law can be. So joining us today is Rabbi Mark Goldfeder, constitutional lawyer and founder of the National Jewish Advocacy Center, to walk us through what these moves mean and what legal tools Jewish New Yorkers still have and how to use them. Mark, welcome back to Basic Law.
Thanks for having me.
Okay, so listen, I don't think I even ran through the full list of hair-raising items that we've seen in the past week, and I'd really like your take on what's happening here, and before we even get to the law, what message it is sending, in your view.
Well, I want to just start off by telling your audience something really important, which is this. It's going to be fine. We are going to be fine, right? When people like Zoran Mamdani make threats, and whether it's in words or policies or postures, it's very easy to feel alarmed, but we have endured far worse than this. We've survived pogroms and expulsions and boycotts and smear campaigns. I don't just mean we, the Jewish people, throughout history. I mean we, the Jewish people, throughout the past 2 years. We've endured far worse than a hostile administration or a demagogue with a microphone, and all we have to do is plan instead of panic. It's also important to realize we don't have, Mamdani derangement syndrome, right? I was a rabbi before I became a lawyer, so indulge me when I tell you that in this we are guided by Talmudic principles. The Talmud in Tractate Nida tells us that when you're told negative, worrisome things about a person, you shouldn't wholeheartedly believe them, but you can and you should take precautions to make sure that you stay safe. So I want to be clear that I still hope and pray that Mayor Mamdani really will turn a corner and be an excellent mayor for all the city's inhabitants, including the Jewish inhabitants. And I want to be clear that none of my concerns are based on his race, religion, age, gender, etc. It's simply based on everything that he has ever said and done and written and stood for and run on. There are legitimate reasons to be worried he might try and enact some of the very policies that he talked about, and already he is doing that.
Let's just make sure that everybody who's listening is up to date on what we're talking about. So the mayor came into office, and from what I understand, new mayors have the right to revoke, renew the executive orders of their predecessors. And what the mayor chose to do was to go back to late September in 2024 and basically rescind almost every order since that point. And that included orders relating to the protection of the Jewish community and Jewish houses of worship, and the establishment of this mayoral office to combat anti-Semitism. He left the office in place, and I believe he renewed the one relating to houses of worship, but there are two key ones that people are quite alarmed by, right? So one is relating to the deletion of the IRA definition, which I'm going to ask you, please, to explain a bit more about. And then the second one had to do with basically a ban on BDS in procurement decisions in New York City, right? And this was like day one. These are two of the things that he refuses to renew. So what, I mean, they were relatively late in the Adams administration, but practically, what did they afford the Jewish community, and what have we lost in your view? And like, what has practically changed as of that
Sure.
decision?
Well, again, it's important to realize that there's the symbolism and there's the practicality. So symbolically, as the Times and the Post reported, yes, he went back and he deleted a lot of the executive orders and erased them, but all that was done sort of as a cover-up, according to the reporting, so that he could easily delete the two, one about the IRA definition and one about BDS, without raising red flags. Of course, it still raised red flags because on the very first day of your administration, you define yourself by revoking protections for the Jewish community. So practically, what does it mean? The BDS one is less practically important because there's still state law which prohibits certain forms of BDS. And so that was really just sending a message that I hate Israel and I'm going to do everything that I can to make everybody know that I hate Israel. But he doesn't have that much power over those BDS type decisions. The comptroller has power. The state law has power. The one that's really, really worrisome is the revocation of IRA. And I'm going to give you a very specific example as to why it's so important and what we lost. That's based in New York. So I don't know if your listeners are familiar with the story of Saddam Massoud. Massoud was an anti-Semite in New York City who on 3 separate occasions a few years back attacked 3 separate innocent American Jewish men, visibly Jewish men, for the crime of being Jewish. Now, his lawyers in federal court had the audacity to argue that Massoud was not an anti-Semite. No, he just hated Israel, and he was so passionate about Palestine that sometimes he lost himself. And of course, he shouldn't have been violent, but it was really just political. He cared so much about Palestine, he felt the need to beat up innocent Jewish men, again, who weren't saying or doing anything about Israel. They were just existing as Jews. They had the audacity to argue this in federal court. And because there is no federal definition of anti-Semitism, it almost worked. Now, thankfully, in that particular case, the prosecutors got Massoud's signal messages, which were encrypted. And in the signal messages, he told his friends, hey, let's go hunt Jews. And when we're hunting them, I think this is almost a direct quote, he said, make sure to say Zionist, not Jew, because my lawyer is fire and he'll get us off. Right? So he knew exactly what he was doing and how you could hide anti-Semitism behind the thinnest veil of anti-Zionism. Now, Massoud is an idiot. So actually, during the third attack, he said to his victim, are you a blank Jew? Before he punched him. He didn't take his own advice. But once they got those text messages, they withdrew and Massoud is in jail. What the IRA definition does is make sure that you can't make that Massoud argument, right? And makes it clear, for example, that holding Jews accountable for actions of the state of Israel, whether you like them or not, is anti-Semitic. And so that when a prosecutor or a judge or an authority figure is trying to determine the motivation behind an already illegal act, like attacking a person, when there's an allegation that it was done because of that person's identity, they can turn to the world's most accepted definition of anti-Semitism. And to call this a contentious definition, again, is ridiculous, right? Over 1,200 entities worldwide, the vast majority of Jewish people across every spectrum. Of course, you have people on the fringes who don't like the IRA definition, but there's the difference between a unanimous consent and a consensus. This is more than a consensus. This is a mandate, and no Jews are ever going to agree on everything entirely. So the bottom line is there were protections in place to make sure that when anti-Semitic things happen in the city, they were labeled correctly, and Mamdani removed that protection and made it much, much easier for anti-Semites to commit heinous acts of anti-Semitism and then hide behind the thinnest veil of excuses to pretend that it wasn't anti-Semitism, it was merely political.
So, like, let's talk about really what your specialty is, which is the legal toolkit to defend Jewish communities and to think about ways of even expanding that toolkit. Now, you mentioned that there are New York state law provisions that, let's say, protect against BDS type decisions in city decision making. There are also New York state provisions that prohibit the disruption of the right to religious freedom at a place of worship, or disruption of a religious service. In fact, the report of the mayor's office, which was released basically as Mayor Adams' parting gift, I think, to the Jewish community, mentioned that these provisions, of course, are in place, but they're simply not being enforced well enough, and that there was more work to be done there. So I don't know if you want to speak to those, but I think what might be most interesting to this audience, because it's not just New Yorkers, but I think that they should learn from, everybody should learn from the New York case. We can speak to federal protections. Those apply to Jews all over the states, and you have outlined several federal statutes in your writing already, the FACE Act, the Section 1983 and Section 1981, and I wanted to go into those a bit more. Depending on how you answer the question, we'll either try to apply them to specific cases or you yourself can illustrate. So those three, I think, or if you have others as well.
Well, I'll start with Section 1981 because it really dovetails nicely with his revocation of the IRA definition. So Section 1981 of the Civil Rights Act of 1866, it's one of the oldest and most powerful anti-discrimination statutes in American law. It was enacted shortly after the Civil War, and it was revolutionary for its time, right? It said that all persons in the United States, regardless of race or ethnicity, would have the same right to make and enforce contracts, to sue, to be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons as property as is enjoyed by white citizens. So today, it has become a critical weapon for protecting Jewish individuals and organizations from discrimination in the marketplace, in employment, in dealings with state or local governments. It's usually thought of as a contract provision, but there's actually more there. And I'll tell you about how we discovered the use of this and how we're going to use it in New York. So some of you may be familiar with our Kim Summerall case from last summer. Make a long story short, our client, Kim Summerall, was attending a counter-protest for a Code Pink event in Washington, D.C., and she was wearing an Israeli flag around her neck. One of the protesters, the Code Pink protesters, grabbed her by the flag and choked her with it. Clear act of anti-Semitic violence, choking a Jewish woman with a Jewish symbol. But the prosecutor and the judge in that case, again, there's no definition there, said, well, we don't see any anti-Semitism here. And that wasn't okay with us. We thought that it is incredibly important that things are labeled correctly. But how do you do that from a civil perspective, right? If there's no civil hate crime enhancement. And so we went back to this provision. And again, if you remember, and I just was quoting that thing, there's this line at the end which says the security of persons and property. It's never been used this way as far as we know, but we said, well, security of persons and property should include physical security as well. And so we brought that case to say that she was attacked based on her race and that it violated the security of persons. And as the court, Judge Trevor McFadden explicitly recognized, Ms. Summerall was not representative of any government. She was just a Jewish woman wearing a universally recognized Jewish symbol, and she was entitled to her safety and security of person, right? And that, I think, is actually the most important ruling in this regard that we have gotten post-October 7th. Judge McFadden said that, and he went probably further than even anyone else would have gone, he said that attacking a Jewish woman with a Jewish symbol is akin to yelling the N-word and attacking a black person. Why is that important to us? In New York City, the mayor can't legally redefine what constitutes a hate crime under state law, right? But he can practically control whether anti-Semitic attacks are recognized as such, right? He shapes the policing, the data, the messaging apparatus, including whether agencies look to the IRA definition, right? He sets very broad policing and prosecutorial priorities. He does this through the NYPD commissioner's mandate and through the Office for the Prevention of Hate Crimes and through interagency coordination, a lot of different things. So what we can do is we can make sure that anti-Semitism is labeled properly using Section 1981 federal law, which applies across the country, even if the administration doesn't. So we're going to plan, if we, God forbid, have to file this new brand of Section 1981 claims in New York City when necessary.
So just correct me if I'm wrong. I think the interpretation of 1981 also applies to people who, let's say, Israel supporters who are not Jewish, who are perceived as Jewish and therefore attacked?
So that's an interesting question. Yeah. I mean, racial discrimination generally is real or perceived. Treating people, there's a fundamental sociological question. Is race just a social construct? Is it real or not? The bottom line is if you treat a person differently because you perceive them to be of a different race, that's racial discrimination, and that's unlawful. And that's why it doesn't really matter scientifically if Jews are or are not a race. Certainly, historically, and even today, Jews are treated differently because of a real or perceived racial discriminatory animus.
And has that precedent from the ruling in the Kim Summerall case already been applied elsewhere?
It has not been applied elsewhere yet, but we have already filed multiple other cases using that precedent.
Best of luck. Okay, so we talked about 1981. Let's move to the FACE Act into 1983.
Well, yeah, let me start with 83 because 83 is sort of a vehicle that will help us get there. So 83, Section 1983 of the Civil Rights Act of 1871, another one of the great enforcement tools of American democracy that was also enacted right after the Civil War, when there were local officials, honestly, who were turning a blind eye to violence against minorities. And now it's become really the lifeline for American citizens when the government itself becomes the source of discrimination. So it doesn't create any new rights. It allows private individuals to sue state and local officials who, under the color of law, deprive them of rights that are guaranteed by the U.S. Constitution or by federal statutes. So, for example, we filed a case in North Carolina, our Gluck case, where we sued the police department for depriving them of their rights under the First and 14th Amendment because they refused to protect a group of elderly Jews who were at a protest. So in this context, it means that if a mayor or a city agency under his power uses its power to target Jewish citizens or to suppress Jewish expression or to penalize Jewish organizations in ways that Mamdani has said that he might do, Section 1983 is the pathway to get to federal court and to accountability. So you have to have a defendant that's acting under the color of state law. The conduct that deprived the plaintiff of a federal right. There has to be a causal link between the two, and it has to be that the person actually suffered injury. So I can walk through those a little bit. What does it mean acting under the color of state law? It means exercising authority that's derived from state or local office. Again, that includes mayors, but it also includes agency heads and police and even private entities that are performing public functions at a government's direction. So the evidence you need are things like official correspondence or permits or funding records or directives showing that the conduct occurred in some kind of an official capacity. Now there has to be a deprivation of the federal right. So what would it look like here? Well, in anti-Semitism related cases, there's a bunch of examples of what that might look like. It could be equal protection, right, which is intentional discrimination here. So you'd have to show that they're members of a protected class, a religious or ethnic identity, Jewish or Israeli, treated differently. Discriminatory intent was a motivating factor, and they were harmed. Let's imagine, for example, that a mayor refuses to give a permit to an Israeli Day parade, or that there's selective enforcement of certain laws outside of synagogues, or there are discriminatory statements made, or procedural deviations, all things that are unfortunately likely to happen. Right. Then there's also the First Amendment, speech and free exercise, viewpoint discrimination. Government can't favor or disfavor speech based on ideology. So again, and take an easy example, denying a permit, let's say, for a pro-Israel rally or protest while you're approving others, that would qualify. It also might include, due process violations, both procedural and substantive. So procedural would be things like depriving individuals of property or liberty, like permits or funding, without notice or hearing. And substantive, this is an important one, would be conduct that's so arbitrary or egregious that it shocks the conscience. It sounds like a very high standard, but actually the court in County of Sacramento versus Lewis said, no, police conduct that is deliberately indifferent or egregious can also violate substantive due process. Again, what would that look like in application? The Gluck case, where the police refused to protect Jewish protesters, Jewish counter-protesters at an event. I would say bottom line, Section 1983 is how you make sure that public power doesn't become the actual instrument of prejudice itself.
Your examples are wonderful because they really illustrate to people, things that theoretically could happen. Some of them have happened. But what about gray areas? What would a gray area look like here? Because very often, I don't think it's necessarily so clear cut why let's say the police don't show up in the numbers that you would have liked, or there's some technical reason, like for instance a fresh start for the mayoral office, that all of the orders going back to late September of 24 are revoked or rescinded, almost, including these that are clearly were clearly targeted to begin with. So where does it get a little more difficult?
I'll walk you through a few different examples, and then we
Okay.
can talk about one, right? So let's start with an easy one in 1981, right? A corporate boycott discrimination, because now they've canceled the BDS stuff. So you have a company that refuses to contract with vendors who refuse to denounce Israel. That's a Section 1981 violation, discrimination based on Jewish or Israeli affiliation as a proxy for ethnicity. Now let's make it a little harder. Theater cancels an Israeli performer's contract. Why? Under political pressure from a city official like Mamdani, right? Now that's a Section 1981 claim against the venue. That's a private bias, but it's also a Section 1983 and 1981 claim against the city for the state involvement. They're going to say, no, you pressured it for other reasons, political reasons. And that's when you're going to get discovery. And that's when you're going to get those internal emails and correspondence that are going to describe things on official emails about why they did or didn't make a particular decision. Take it a step further, a municipal contracting bias, right? A city refuses to lease public space to a Jewish community organization, and it says, no, it's because of security concerns, right? But it approves others with similar risk profiles, right? That's a violation of 1981 and 1983, equal protection and contractual rights. And we're going to use the disparate impact and the similarly situated comparators as evidence of discriminatory intent. Bottom line is that we're going to look for evidence in statements and correspondence and everything from text messages like Saddam Hussein to official proclamations from the mayoral office about what the real intent was. And again, when you look at how they treat other people, it's very, very clear to see that there might be a difference. So, for example, they didn't rescind any other orders protecting any other minorities.
In the same time period?
Yeah. I mean, again, I don't know that there weren't necessarily any, but you choose an arbitrary time period in which the only people being affected are Jews. It speaks volumes.
The truth is, I actually wanted to see what the full list of those rescinded was, and I couldn't seem to pull it up. But that's probably for a time after this show. So, okay, so we have one more left to go through before we move on, and that's the FACE Act. And actually, I remember talking with you about a precedent that you got on our previous episode. I'd love for you to discuss it again in detail, but I just want to mention it because that episode, too, has a few gems that I think we may not get into this time. Talk to us about why the FACE Act is important.
Sure. So the FACE Act is a Freedom of Access to Clinic Entrances Act. It's usually an abortion clinic act, freedom of access to clinic entrances, but there's a paragraph 2, which nobody reads, which says, or houses of religious worship. Back in June of 2024, there was this pogrom outside of Adas Torah Synagogue in Los Angeles. And we used the FACE Act to sue Code Pink, which is an anti-Semitic nonprofit that organized this violent attack. They were blocking the entrance to a house of worship in violation of both California state and federal FACE Act laws. Now, they responded and said, no, this was just an aliyah event, just a real estate event, not an act of religious worship. To which we responded and said, no, not only is aliyah a mitzvah, a commandment that the Talmud considers equal to all other commandments. In fact, according to several Rishonim, including the Rivash, the early commentator, even hechsher aliyah, preparing to make aliyah, is a partial fulfillment of this mitzvah. The judge basically said, I don't want to touch this with a 10-foot pole. We string cited all the very real sources. And so now, for the first time, aliyah is a protected religious right under the First Amendment in the United States. The Department of Justice liked this. They put a statement of interest into the case saying this is a correct usage of the FACE Act. And then they formed their own FACE Act team. And their own FACE Act team on September 29th brought a very similar case in New Jersey. Again, building off this precedent that we had set in the FACE Act case in Los Angeles. Since then, they've begun investigating at least 2 more, right? Those 2 more include Wilshire Boulevard in Los Angeles and Park East Synagogue. Interestingly enough, in the Wilshire Boulevard case, again, public reports show that the same group that organized that protest were planning 5 different bombing attacks, terrorist attacks on New Year's Eve, and they were shut down. Now, I don't know that the investigation was spurred on directly by that FACE Act, but to the extent that it was, it seems that the Rivash may have prevented a terrorist attack in 2025. So an interesting sort of confluence of circumstances here. Now, why is the FACE Act important here? Because, again, we're looking at what the mayor has already said and already done, right? When there was an extreme anti-Semitic protest outside of a synagogue, instead of just condemning the protesters, what Mamdani did was condemn the synagogue for daring to host an aliyah event. And he did it by an appeal to non-existent international law. There truly is no such international law. And to the extent that there was an international law, it has nothing to do with New York State. Mamdani, as a mayor, is bound by the Constitution, by state and local laws. Nothing to do with international law whatsoever. But to the extent that he thinks it is a problem to host aliyah events, it is very possible that we may have to rely on the FACE Act to make sure that these protesters don't come back.
Okay, so let's do a very, very quick summary before we move on to the next question, which is about Checks and balances in New York.
Section 1981 will make sure that when anti-Semitic things happen, they are labeled correctly. Section 1983 is the vehicle by which we'll get to federal court. The FACE Act is how we're going to protect synagogues. And there are a number of other things that we plan on looking at as well. Defamation, for example, is something that might really happen, depending on if he continues to talk about Jewish organizations and accuse them of international crimes, right? Those are false and defamatory statements that are published to a third party. When it's a public official like Mamdani, it would need to be actual malice, which means knowledge of falsity or reckless disregard for the truth. Certainly, we have reckless disregard from the truth, and there is harm. If you want to federalize that claim, right, you can bring it through Section 1983.
Okay, so you just mentioned in your answer, look, Mamdani does not act alone. He's within this larger system and bounded by the Constitution. There's clearly a role for the city comptroller to play, for the governor to play, for the state legislature to play. And I wonder whether people are really attuned to just the ways in which these institutions can check the office of mayor or partner with the office of mayor, and whether that might not inform some planning on the part of the Jewish community in New York City. And it's not just the mayor, right? How do we think about the power structure checking him?
I mean, the truth is Mamdani is actually probably in for a civics lesson as he realizes that the mayor matters a lot, but the mayor is not all powerful. So there's a number of formal checks. There's a city council, right? That's a legislative check. City council can override, for example, a mayoral veto with a 2-3 vote, 2/3 vote. They can pass laws. They can approve or reject the city budget, which is incredibly important for a lot of the plans that Mamdani said he's going to put in place. They hold oversight hearings, issue subpoenas. They can confirm or deny certain mayoral appointees. Then there's the sort of structural checks, right? The New York City Charter itself, it divides power between the mayor, the council, the comptroller, the public advocate. There's certain procedures like procurement and rulemaking and record keeping that it requires. There's independent-ish bodies, COIB and the DORIS bodies, which, keep track of records and things. And you can challenge violations of the charter, even by the mayor, in state court using what's called Article 78 proceedings. In fact, we sent a letter yesterday to Mamdani warning him about potential Article 78 proceeding violations when he stopped the daily briefings of Jessica Tisch on intelligence.
I saw that. Could you just explain what you were addressing there? I saw the letter.
Yeah. The public reporting is that, well, first of all, Executive Order 2, so not public reporting, says that going forward, the police commissioner, along with several other agencies that have nothing to do with law enforcement, is going to report to the first deputy mayor, who, by the way, has no law enforcement experience, whereas traditionally they have reported to the mayor. Now, Mamdani came out in response and said, oh, no, that's just he coordinating day to day, but she'll really directly report to me. Well, it's unclear what that means, because the other reporting was that he stopped the briefings that have gone on daily since 9/11 between the police commissioner and the mayor on the kind of threats facing the city that are still, unfortunately, extraordinarily relevant. New York City is at the center of terrorism prosecutions, including most recently Maduro, and to suddenly say I'm going to turn a blind eye and pretend that there's no danger facing the city, that's reckless.
Okay. So there's the charter, the comptroller, the city council.
Well, the comptroller, right, they sort of the financial checks, right? So they audit city agencies, they review and reject contracts, they oversee pension funds. There's a public advocate. That's not really a strong check. They can introduce legislation. They can sue the city. It's sort of an ombudsperson. There's no direct executive authority. It's mostly a platform. The real serious check here, to be honest with you, is courts, right? State and federal courts can enjoin executive actions that are unlawful. They can enforce state law, including, for example, state anti-BDS statutes or civil rights laws, or federal laws. Again, Title VI, the First Amendment, equal protection, Section 1981, Section 1983. So, in terms of the mayor, if there's selective enforcement, if there's viewpoint discrimination, if there's failure to enforce mandatory duties, if there's unlawful record destruction like we had on day one potentially, if there are procurement violations, this is the hardest constraint on a mayor that pushes too far. And so we have to be ready with all of these tools.
I grew up in New York. I know that you've been there a lot, but I'm not sure if you...
I grew up in New York.
You did?
Yeah.
Okay, great. So then where?
25. I lived there for 25 years.
In?
Brooklyn then upstate in Rockland County, and then the last 8 years in the city.
All right. Well, Queens in the city too. Okay. So then you know exactly what I'm gonna say, but I'm gonna just lay this out. There's like really kind of uncomfortable political math coming in from the kind of the Jewish community, right? There's data from the CUNY Center for Urban Research, or the CUNY, I think it's at the CUNY Graduate Center, which basically shows the split of the vote in November. And just to give some examples, this is quoting research from that was cited in a Forward article. In Borough Park, Hasidic voters turned out at unprecedented levels. You had one district that jumped from 280 voters in 21 to over 1,000 this year, and Andrew Cuomo took 88% of that vote. Mamdani got 6.6%, and you find similar kinds of margins in Midwood and Crown Heights in Williamsburg, not so surprisingly. But then you move to neighborhoods with predominantly more progressive or liberal Jewish populations in them, and you get 75% from Mamdani and Park Slope, and similar stuff in Prospect Heights, Clinton Hill, Fort Greene, etc. Upper West Side split evenly. Upper East Side went 2-1 for Cuomo. So we have a very divided Jewish vote, and the Jewish vote itself is numerically less powerful than it used to be. I remember when I grew up, I think that the idea was that there were about 2 million Jews in New York City. And now, at least according to the mayoral documents that I was reading preparing for this, we're under 1 million. Given that the Jewish vote is so varied, how do you think about this, right? Obviously you say courts is like the biggest check on the mayor, but does there need to be some other way of thinking about internal coalition building? Is there some potential for it?
First of all, Mamdani winning does not mean that New York City Jews broadly endorsed his positions. Right? A lot of the studies, including one from DropSite, was comical because, well, if you take out all the Trump voters, then Mamdani performed incredibly well. Okay, so if you take out, again, as you said, all the Haredi and Orthodox Jews, which is a large percent of it, then Mamdani did exceptionally well. He didn't do exceptionally well. Jewish voters are always going to be divided, and the key takeaway is this: Jewish safety in New York City cannot rely on mayoral goodwill, right? Mayors don't need our vote to win, right? Protection has to come from things that are not optional. It has to come from the law. It has to come from courts. It has to come from state preemption. It has to come from federal rights enforcement. It has to come from, unfortunately, litigation readiness, right? Power now has to run through institutions, not through the city hall. And I think that Mamdani demonstrated that he said this. He said, I don't need you to win. And he didn't. He didn't need us to win. He won. And now what I think he's trying to do is push the Overton window as far as he possibly can, right? You know, it sends a real message when you take an Al-Qaeda lawyer as your chief counsel, same person who also defended Mahmoud Khalil, one of the lead instigators and activists who were fighting and honestly providing material support for terror, in my opinion, to Hamas over the last couple of years. These are the people he's putting in place. And what he's saying is he's snubbing his nose at the Jewish community and saying, I don't need you and I can do what I want. And that's fine because we don't need him. And we can also do what we need to do, again, using courts, preemption, federal rights enforcement, and litigation readiness.
Well, I can't think of a better place to end than there. I wish you really incredible success, both in spreading your message and, of course, in the cases that you are currently and will be litigating. And
I hope and pray that none of this at all becomes necessary and that he has an incredible epiphany where he realizes that Jews are people too and are equally worthy of protection just like everyone else.
I would agree with that. And, you know, alongside that, I would simply reiterate the message that we opened with. You were talking about messages. So what happens in New York is a message, right? And the Jewish community there, at least the part that's quite concerned about this, should just kind of, I hope, realize that it has the tools. You've mentioned a good number of them. You are one of them. And so are a number of great organizations that work on this kind of stuff. Thank you so much. I know that you've waged a hard battle with a cold to talk with us. Same here, by the way. And I'll talk with you, I hope, in the coming months.
Thanks. Talk to you soon. Good to see you.
Good to see you too.